things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, "Oh, I'm just gonna JV it." Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today. So thank you so much.
Well, then that end buyer could come back and say, "Well, I didn't fully understand that it was subject to."
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, good morning, everybody. Welcome to the show. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on Facebook. You can find us on YouTube. On YouTube, we are at INREM Podcast. That is at INREM Podcast. Make sure to join us. Today, we're talking about the intersection of community property, divorce, and real estate. With that, we're going to turn it to Sean, who has our legal update.
Yeah, so my legal update today is talking about using state purchase contracts to acquire property through creative financing. And what I mean by that is, as the market shifts and changes, there may be opportunities to pursue properties that are listed with a real estate agent and pursue them through creative finance, meaning you're going to purchase the property through either the seller providing some form of seller carryback financing because their property is owned free and clear, there's equity, or there's a loan against it. And so you're going to go and you're going to purchase it subject to that existing loan, and you're going to make the payments on that existing loan. And a lot of time investors go when they try to present their custom-made purchase contract to the listing agent, and the listing agents are generally not real thrilled with that prospect. And so, of course, they're less than positive probably when they present it to the seller, because now they're having to sit down and try to figure out a 8 to 10 page creative finance purchase contract and the addendums and explain those to the seller versus sticking with the form that they know, which is the state, in our case, the Arizona Association of Realtors form purchase contract, where they know it. They take classes on it. They part of real estate school is learning the contract. And so they know the ins and outs of that contract. They don't want to spend hours upon hours sitting there reviewing a custom drafted purchase contract to understand the nuances, make sure they haven't missed anything that's going to somehow majorly damage their seller. So what I would encourage is, if you're going to pursue a property that's listed for sale, the purchase through creative financing methods, then use the state form. So for example, if it's going to be a straight seller carryback because the property is owned free and clear, then use in Arizona, use our state form with the seller finance addendum, which is perfectly fine and would provide a great template and form to be used for that situation. Or if you're going to pursue it with a subject to purchase, then use the state form, but have some form of wrap financing or subject to financing addendum that you incorporate that's a couple of pages long that basically accomplishes what you need to accomplish for the nature of that transaction, which is disclose to the seller and make sure that the seller fully understands and appreciates the nature of the transaction, the due on sale costs, and the risk involved. But don't try to shove your custom made purchase contract, through and to the real estate agent, because once again, it's outside of what they're comfortable with, and you'll receive a better reception if you use their form and simply attach an addendum.
All right. Thank you for that, Sean. Quick reminder for the listeners, we have our upcoming Creative Finance Symposium Not this Thursday, but the following Thursday, May 4th. Remember, we do the Creative Finance Symposium every other week, and that is our chance and your chance to spend an hour doing a deep dive into some aspect of creative finance. And it gives you an option to not only spend about 30 minutes learning about a particular area of creative finance, but to ask Sean and I detailed questions about the topic at hand or about any topic relating to creative finance in that. So it's a tremendous opportunity for you, the listener. It comes at no cost to you. We ask that you just show up, sign up, and attend and be there with us and be there ready with questions. Sean, why don't you tell our listeners what the topic is this coming next week?
So this next week, the topic's going to be lease with options to purchase. And we're basically going to go through, and it's going to be for acquisitions. We're going to talk about the provisions that you would want in a lease that you're going to use to basically obtain possession of the property, and then what you're going to want in an option so to purchase at a later date. It basically, the lease with option allows you basically to go in and take over possession of the property and to utilize the property for pretty much as your own, to sublet and things like that. And then you have a later option should you decide you want to purchase it. But we'll talk about that. We'll talk about what that looks like as far as like due on sale clauses are concerned, those types of things.
All right. An additional reminder for today, we are taking questions today like we do every week. And we try to reserve the final 15 minutes of the show to you, the listener, to ask questions about our topic today. And a reminder, our topic today is the intersection of community property, divorce, and real estate. There's a lot of intersections that happen there, and it's hard to do a divorce and family law without there being an interaction with real estate. So we're going to be talking about that, but we want you to be prepared with your questions. And with that, I'm going to turn it over to Mayu, who's going to give you directions on how you can go ahead and prepare and set that up for us.
Happy Tuesday, everyone. Thank you for joining us live on the NREM podcast today. And Andy is right. If you've joined us on the show before, you know that we will be taking questions live on the show. So if you're watching the podcast, whether it's from our Facebook or YouTube pages, we are monitoring the chat for your questions so we can take the last 10 to 15 minutes of the show to answer them. And today's topic, you heard it, is the intersection of community property, divorce, and real estate. We take questions in order of priority, so don't wait. If you have a great question in mind related to today's topic, make sure to leave it in the chat and as specific as you can be, and we'll try to get to all the questions at the end. So we're ready to get into it.
All right. Thank you for that. Yeah. Don't wait to the end. If you think of a question now, go ahead and post it. We'll for sure get to it. All right. So let's talk about divorce, real estate, family law, and the intersection of all of those. And, you know, Sean, you and I have talked about this a lot, and I don't think most people appreciate how often the topic or the issues of family law do intersect with real estate. Because when you think about it, the one big asset that just about every couple is going to have real estate, right?
Yeah, that tends to be for a middle-class family, the kind of the primary asset. I mean, that's where the money's at generally. And so there can be, you know, a fight over that in the divorce proceeding. And then, you know, we've seen where property was awarded to one spouse, and a few years later they try to go and sell it and they realize, yeah, it wasn't done right. And now either they have to obtain or secure the cooperation of the other spouse, they have to go back into court, you know, and it becomes kind of a mess and will delay a closing and cost funds in attorney's fees and things like that. So it's very important to really understand the community property and divorce aspects of real estate.
Well, yeah. And not only that, you know, we talk about this in estate planning, but real estate itself is a highly technical thing. Oftentimes it doesn't look like it. You know, we're conveying real estate by what looks like a simple document, be it a warranty deed, quitclaim deed, or some other deed. But real estate involves legal descriptions. Those things are easy to get wrong. We never like clients to do that on their own. We like to do that for them, or use a title company to ensure those things are correct. If you've got the grantor, grantee information, you can create all sorts of title problems. And when you mix another practice area filled with individuals and lawyers who may or may not be versed on the real estate side of the equation, it can create all sorts of problems, and it can create opportunities as well. So a lot of what we're going to get into today addresses a lot of that and the intersection of those two. So let's start from the beginning and try to give the listener and you guys really a basis from which best to understand family law and real estate. And we think probably the best place to start is an understanding of community property, how Arizona uniquely treats assets held by a spousal community, those that are married under the law. So, Sean, why don't you go ahead and give a description as best you can of community property and explain why that's important to understand.
Yeah, so community property is the presumption that any asset acquired after marriage belongs to both spouses 50-50. So they each have an undivided 1/2 interest in that asset. So one spouse is out there working, they make $1. That dollar belongs to both spouses. So each spouse owns 50 cents, but each spouse also has the full right to do with that dollar whatever they want. So it's the presumption that there's this community estate that's created upon marriage, and every asset acquired post-marriage is presumed to be community property and belong to that community estate.
What I think can add to the complexity of this is that family law and asset laws, so to speak, as they apply to married individuals, is not consistent across the board in all 50 states. It's kind of a mixed bag of community property and kind of individual property type states, and certain geographies or geographic regions tend to be maybe community property regions where others aren't. And I think sometimes what you get are individuals who may be used to how assets are owned, let's say on the other side of the country, and they move to California or Arizona, and they've got this thing like community property. I think that adds to some of the complexity. What do you think?
I do, because it is such a mixed bag. We're in the minority as far as community property goes. So Arizona kind of falls in the minority. It's kind of a West Coast thing. And so, most of the West Coast states have community property laws, and each of them are a little bit different. Arizona's are pretty cumbersome. And if you get it wrong, it could be very damaging in just all contexts, from real estate to judgments to divorce. It can create major problems if you misunderstand community property and you go into a transaction believing one thing, but then in reality, community property laws kick in and you have a whole different circumstance.
So the presumption in Arizona, as you discussed, is a presumption that assets owned in marriage are community property. So within every general rule and every presumption, there's an exception.
Right.
What is the exception in Arizona to that presumption of community property?
Yeah. So first, any assets brought into the marriage. So I said anything that you earn post-marriage is presumed community. Well, the opposite is true, which is anything you bring into the marriage, and frankly, you need to keep it separate. You don't commingle it with community assets, but you bring it into the marriage and you keep it separate. That will be an exception to the community asset presumption rule. Second is anything you inherit during the marriage. Once again, if you're going to keep it and maintain it as your separate property, you have to keep it separate. You can't commingle it with community, property and community funds. And then anything that you're given. So if you receive a gift from a family member, or your parents or somebody like that, then that gift will be presumed sole and separate property unless, once again, you commingle it. And then in that case, it's presumed that it's been transmuted to community funds, or it's been gifted to the community. So you have to always keep it separate. So anything that is sole and separate needs to be maintained and kept sole and separate. It should not be combined or commingled with the community estate, if that's how you want to keep it. I mean, there are people who are like, no, I don't care. I want it to be part of my, marital community. And therefore they just put it in, and then it is gifted to the marital community and becomes that, and there's no issues until there is an issue. Right. But, if you keep it sole and separate, it'll remain sole and separate.
So, I mean, what you're saying at the end of the day is we have these general rules. So the first step is understand the general rule. But when we talk about an exception or a presumption to that, what we're really talking about are the facts as they play out and how you treat the property after the fact. So the property you bring to the marriage that belonged to you before your marriage is yours until you do something that rebuts that presumption, and vice
Right.
versa with property. So give examples of what do you mean by that? Like what kind of factual things can spouses do that when you say transmute and
Right.
do? Are we really just talking about commingling funds at this point?
Well, a real simple one is you inherit assets, and you maybe even keep them in a separate bank account under your name. And then you and your spouse decide you're going to purchase a house, and you'd use your inherited funds as a large down payment on that house. And you and your spouse go and take title to the house as community property with right of survivorship, which most married couples are going to do. You don't even really think about it. All of a sudden, that down payment is now community property.
Right.
Or you inherit, and instead of creating a bank account in your name, you simply say, oh, I'll just put it into the bank account that I share with my spouse. And then you guys start using it for, different purposes, to improvements on the community, home, to have vacations together, to do this or do that. And then you can't figure out what was used for what. And it's just, 5 years later, if there's ever a divorce, it's just all commingled. So, nobody can figure it out. And then the presumption is, well, that was just a gift then to the community.
Yeah. And to be clear, that might be your intention to just make it
Yeah.
all community property.
Right.
And that's okay if that's what you want to do. What we're here to do is try to explain there's implications, and there are going to be further implications to asset ownership and how you hold those assets. And if you have intentions going into it, better to plan so you can accomplish the goal of what your intentions are. So I think what might be helpful as an illustration to show the consequence of how assets can be held community property or separate property or not. Let's talk about liens that attach to property, like judgments.
Yeah.
What does that look like, and how does that impact the ownership of property, whether community or sole and separate?
Yeah. So the rule is that if a married individual is served with a lawsuit that names just that individual and doesn't name their spouse as a defendant, the judgment that's entered is only going to be enforceable as to the sole and separate property of the spouse named in the lawsuit. So this is common. This commonly happens. Let's say before I'm married, I go and obtain a credit card. I rack up a huge credit card bill. I don't pay. And then I subsequently marry. And 2 years after I'm married, the credit card company, because it's a 6-year statute of limitations, right, on credit cards. So it could be a while. They decide, oh, we're going to collect against Sean, and they file a lawsuit, and they name just me in the lawsuit, and they don't name my spouse, and they end up with a judgment. Well, unless I've kept separately a bunch of sole and separate property in my name, that judgment's not going to be enforceable because they're not going to be able to pursue my community estate, even if let's just say I'm the sole breadwinner for the family. I'm the one that's, working the 9 to 5 and making the money and that type of stuff. Even if I have, W-2 wages that are coming and being paid to me and whatnot, all of that, because I'm married, that's deemed community property. And because that's community property and the judgment is only against me, and my spouse hasn't had an opportunity to go into court and object to the lawsuit and the judgment and that type of thing, the law says, well, it doesn't attach to anything that I earn after I'm married. So that judgment could likely be, unenforceable. Now, let's say that now I can't marry away a judgment. So let's say that same scenario, I have a credit card, I rack up a large debt, I don't pay, credit card company sues me, I'm single at the time that they sue me, judgment's entered, and then I go and marry, that doesn't matter. Then the judgment creditor has a right to garnish or collect up to 50% of the community estate. So my share of the community estate, which is 50%, they can base that portion. So they could garnish my wages and take up to 50% of my compensation. Although, the percentage in Arizona is less than that, but they could, and they would have the right to that, or they could garnish my wife's and my bank account and take up to 50% of that. So, I can't marry away a judgment. So just keep that in mind. And that would apply even if, say, my wife was the main breadwinner and she was making all the money and we were putting that into the bank account. They could take 50% of that, even though that's not like my W-2 wages or my income.
I think it's worth noting as well. We've been talking about assets as community property, but there's obligations as well of a community, right? And there's laws in Arizona that specifically address how the community can be obligated, how one spouse can obligate the entirety of the community assets, and in some cases, the law requires both spouses. But once you're married, one spouse, as a general rule, can obligate the entire community, correct?
With some exceptions, of course. Yes.
Right.
So a spouse could go out and obtain a credit card that the other spouse doesn't even know about. And that would become a community debt. Because otherwise, think about it. How could you even operate? You have a spouse go to the market and buy a bunch of groceries, and the other spouse comes back and is like, no, you can't charge us for that because I didn't sign, I didn't agree, that type of thing. It wouldn't work that way. But there are exceptions to that rule. So for the most part, one spouse can fully manage the community. They can pull money out of the bank. They could write checks to people. They could do anything they want with the community estate, with some exceptions.
It's really not a whole lot different than an LLC with two members.
Right.
Both of them have the right to act on behalf of this thing. And in community property law, this thing is this kind of marital unit. So let's talk about now the intersection of community property and how that impacts real estate ownership, because there are implications there both on the acquisition, the disposition, and all the way through. So let's talk about the acquisition of real estate. What's required of the community to acquire real property?
So any acquisition or disposition of real estate for or by the community requires the signatures of both spouses. So one spouse cannot bind the community to a real estate related transaction. So this includes a purchase contract. So let's say my wife's working with a real estate agent and she finds a house and says, oh yes, let's do it. And the real estate agent writes up the purchase contract and puts it in my wife's name because that's who, they've been working with. They submit the purchase contract to the seller, which says that we're going to put, $5,000 of earnest money down. The seller accepts it. they open escrow. My wife writes a check from our joint bank account for $5,000 to the title company. And I later decide, I don't really want this house. Maybe even I was on board, I was on board and everyone thought I was on board, but I haven't signed anything. And I'm like, nah, I don't want this house. I can go to the title company and I can go to the seller and say, hey, look, where's my signature? And unless they have my signature, that contract is no more. And I can void that contract, receive a return of the $5,000 earnest money, and that transaction is like it never existed. Except if my wife were to have her own sole and separate property and can prove that she wrote the 5,000 out of the sole and separate, or they could prove my wife wrote it out of her sole and separate and she was going to purchase it as her sole and separate property, then maybe they could keep the earnest money. But assuming that married couples, for the most part, just have community property, then I could show up as the non-signing spouse and basically set that aside. Same applies for mortgages and deeds of trust. So you want to lien up your property, both spouses have to sign that, even if the loan is just in one spouse's name. But if it's going to be a community property, then both spouses have to sign for that. Or I'll get to this in a minute. Or one spouse can sign what's called a disclaimer deed, which basically says, yes, I understand that this is probably for the benefit of our marital community, but I'm going to disclaim any interest I have in this property in favor of my spouse, and therefore she can do with it whatever she wants. And upon executing that disclaimer deed. Now, the one exception, go ahead.
No, I was just going to say, I'm glad you brought up the disclaimer deed, because that's one of those things that most people have probably seen and not really appreciated or realized that that's the title company and the lender's concern over Arizona's community property laws and the presumptions, right? This is their ways to ensure that there's clarity on whose this is.
Right. So the one exception on real estate interests would be leases. So a lease of a year or longer requires the signatures of both spouses. If the lease is less than 1 year, one spouse could bind the community to that lease.
Okay. Now, I think, correct me if I'm wrong, I think that you already addressed the hypothetical of where the one spouse has received an inheritance and they want to use some portion of that to purchase. If they're going to keep it, and if they're going to keep that in the sole and separate name of the spouse that received the inheritance, then they don't need the signature of both, but will probably need a disclaimer, or are going to need a disclaimer from the other spouse.
Well, it depends, right? So if I have sole and separate property and I go next door, knock on my neighbor's door, and I'm like, hey, I just inherited this money. I want to buy a house. I heard you're interested in selling your house. Yeah, I'm interested. All right. I have enough to buy it cash. Will you sell it to me? Yep, I'll sell it to you. Now, we could enter into a purchase contract. I could cut a cashier's check for the full value of the house. I could prepare a warranty deed. I could have my neighbor sign the warranty deed, give me title to the property. I could record that warranty deed. And guess what? I own that property. Okay. If you notice, I didn't mention escrow agent anywhere. I didn't mention title insurance. So I would own it, but I wouldn't have title insurance. So if somebody else came out of the woodwork and said, oh, your neighbor sold it to me first, you're out of luck. I might be out of luck and I may be out all that money. So I could use an inheritance. I could buy property as my sole and separate property. I could prepare the warranty deed, and I don't need my spouse's signature at all. But if we go and we open escrow, my spouse is going to have to participate in that transaction. And you've already hit on it, which is the title company is in the business of mitigating their risks. So the title company is going to be like, okay, this is great and all, Sean. I understand you inherited this money. I understand you want to take title in your sole and separate name. I understand you have this, purchase contract out there. And I understand that Arizona law says that if you've inherited the money, that it's presumed sole and separate property. But how do we know you inherited the money, right? How do we, like, I don't want to rely upon, some bank statement. I don't want to rely upon your word. I want to know that this is truly going to be your sole and separate property. So the only way for us to really know this is for your spouse to show up to title and to execute a disclaimer deed, basically saying, yes, this is Sean's sole and separate property. It's not mine, and it should be placed in his name. And you can issue an insurance policy saying that it is his sole and separate property. Because what's the title company concerned about? They want to make sure that my wife doesn't show up 6 months later and be like, hey, did Sean purchase a property through you guys? Yeah. Well, that's our marital community, and I never agreed to it. Well, what do you mean? Well, he took money from our marital bank account and put it into his checking account in his name and bought the property. Well, now title's in a world of problems, right? They're having to unwind the transaction. They're having to, potentially give money back to the seller. They're taking it from me and the whole thing. And they have some liability and exposure there, and they don't want that. What they want to do is make sure they have a nice, clean transaction, and that if they prepare a warranty deed that says it's my sole and separate property, that it truly is my sole and separate property, and we have a good transaction, that somebody isn't going to hopefully come in and basically easily set it aside.
What about issues dealing with limited liability companies? We've got a lot of listeners that are dealing with LLCs that are doing real estate investing, and maybe they've got their spouse on the LLC, or maybe they don't, but they're thinking, well, I'm the manager of my limited liability company. I can go sign on this. Not a big deal. What are circumstances you see where it is going to be a big deal, that your spouse is going to need to be a part of it, or may be a part of it, and community property law might have something to say about it?
So a common scenario is, banks don't want to lend to just LLCs. And so let's say you have
especially
an LLC.
Ones formed like 3 minutes before the
exactly. So let's say you have an LLC that, their business is fix and flipping properties, right? And they have a hard money lender, and they go to the hard money lender and they're like, hey, can you loan us this money to, do these improvements on this property? And the hard money lender, sure. Well, the LLC will be the borrower because it owns the property, and we'll take a deed of trust against the property. But they're generally going to want a personal guarantee by the owners, because if the LLC decides, they get in the middle of the project, it's not going well, the market changes, the property goes down in value, and they're like, forget it, it's not worth it, and the LLC just walks away, well, the lender could be stuck holding the bag, because like the LLC's only asset is the property. Like you said, it was formed 3 minutes ago, and the only reason it was formed is to take title to the property. It has no other business. There's no other assets. And so if the property's underwater, or, in partially remodeled, like, what's the lender going to do? They, don't want this, and they're probably in second position anyway. So what they want is they want a personal guarantee. They want the owners of the LLC to say, yeah, if the LLC can't pay you and you can't get it from the property, I'm good for it. I'll personally write the check to you and pay you off. It's unfortunately never that simple when, everything hits the fan, but nevertheless, that's what you want, right? You want a personal guarantee where they say, I'm going to pay you. However, if that owner is married, a personal guarantee generally from just the one owner and not their spouse is going to be unenforceable, because that's something that a signature of one spouse cannot bind the marital community to, which is a personal guarantee. You have to have the signature of both spouses to access the community. So if I own an LLC, I go to a hard money lender, I go to obtain a loan. In that case, the hard money lender wants a personal guarantee. In that case, I need to have my wife sign it. Otherwise, it's probably going to be unenforceable unless I have a lot of sole and separate property out there for the lender to, enforce upon. But chances are most people, at least my experience in Arizona, most people don't have sole and separate property. Their assets are marital community assets. And so that personal guarantee would be about as worth the paper it was written on. It wouldn't be enforceable without the signature of the spouse.
Yeah, it's a mistake that's easy to make. It's interesting how the community is really afforded more protections when you're talking about a guarantee than just a normal contract. Because had the creditor or the lender just dealt directly with either spouse, that obligates the community.
That's
as
right.
From the perspective of a loan.
Right.
Where I've seen this mistake made a lot is in commercial landlord-tenant law, where you've got the tenant, brand new business, Sid's Cigar Shop LLC, has decided to open up their new pipe, tobacco, and cigar shop, and they're dealing with a big landlord. So they've created their LLC and they put that on the contract. But with a new business, that commercial landlords always wants a personal guarantee. Sometimes these landlords might be from New York. Maybe it's a big New York company that owns a bunch of properties all over the place, and they're dealing with 50 states, and they may not even be a local landlord.
Right.
And they're like, well, we need a personal guarantee. And they're not very careful, and just one spouse signs the guarantee. Like you just mentioned, that's basically going to be a worthless guarantee likely as to the community property. So it's an important feature to be aware of on the debtor side of things, as well as on the creditor side of things, to know those exceptions. And that one exception can really change everything. Because in that commercial landlord-tenant context, by the time it matters, that's when that's when a tenant's gone into default and they owe money.
Right.
And the little Sid cigar shop isn't going to have any money. You want to be able to go after the individuals and the community. So let's take the next step and let's talk about, after having looked at community property and what it looks like to own sole and separate property, community property in a marriage, we know that oftentimes in marriage, unfortunately, it can result in a divorce. So the severing of the marriage. And we mentioned before, really, there's almost no divorce that happens, or they're pretty rare that happen, that isn't involving real estate. I mean, that's most of middle-class families out there's primary assets. So real estate is going to be implicated typically in a divorce. So at the end of the divorce, which is the equitable division of the community's assets, or the assets to know how those are going to go, there's going to be a determination. There's going to be a divorce decree that severs that and makes determinations on who gets what and how that goes. How can somebody who's in that ensure that when the court does make that judgment, they don't do anything that's going to create any title problems or vesting problems with the real estate that they're dealing with?
Yeah. So unless that decree has some magic language in it, there's going to be problems later on. And Andy and you have both seen this, where we have clients who come to us, many years after the divorce, and now they want to pick our real estate brains because we're not divorce attorneys, but they say, hey, look, I was awarded this property, or maybe it's the spouse that wasn't awarded. And they say, hey, this loan is still in my name. I'm still on title. I just want this done. What are my options? Why wasn't this done the first time? And the reason is because, divorce lawyers and even judges don't appreciate the title issues that have to be dealt with and that are going to crop up later on if it's not, properly prepared, so that you have some language in there which actually effectively separates the owners from the real estate, or the non-awarded owner from the real estate. So one simple one is, assuming that the real estate is owned free and clear, for example, or there's provisions in the divorce decree as to what happens to the existing loan on the property, and one spouse is being immediately removed as part of the divorce, assuming you're negotiating a settlement, which most divorces are going to end with a settlement. You're not going to have a judge basically ordering a resolution on all issues, including the real estate. But assuming that the parties are negotiating and have negotiated a resolution, the easiest thing to do is just as part of the entry of the decree, before the settlement is finalized and the decree is entered, require that the spouse that's not being awarded the property execute a warranty deed in favor of the spouse who is being awarded the property, so that title is clearly and undoubtedly in the spouse who has been awarded the real estate. So that's one simple thing that can be done to make sure you don't have title issues later on. The other is to make sure, if you can't do that or you don't do that, make sure that the decree has magic language in it as to the conveyance of the real estate. So first, it has to have the legal description to the property. The address, the assessor parcel number is not adequate, and title companies will not insure title in the name of the spouse who was awarded the property without that. Something else will have to be done should that spouse want to sell the property at a later date. So the divorce decree must have the legal description. Then it should state clearly and expressly that all right, title, and interest in and to the property is vested and awarded to the spouse effective as of the date of the decree, and no further deed or conveyance is required. So basically, effectively, what you're doing is saying that the divorce decree is akin to the deed. It is what is being utilized to vest title in the name of the spouse for whom the property is awarded. And if you have that magic language in there, it's likely that a title company is going to insure title in the name of that spouse and allow that spouse to sell the property without any further participation by the spouse who was not awarded the real estate.
Yeah. Otherwise, and alternatively, you're at the mercy on the hope and a prayer that you have a cooperating ex.
Right. Or you have to go back to court, which
Or
is
you
a
gotta go
real
back to court.
pain. Yeah.
So if you're a real estate investor and you're looking for deals and you come across one and they mention divorce decree, or I was awarded to me in the divorce, you're either looking at right away the decree.
Right.
If there is no deed, if no
Right.
deeds been conveyed, you're wanting to get a hold of that decree, right? Or
Right.
the settlement.
Right. And the decree would be recorded. So I've had cases where and we've mentioned them already, where it's a mess because the decree didn't have the right language. But I've also had cases where the decree did have the right language, but it never was recorded. And so the client comes to me, says, hey, title is having a problem, blah, 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 blah. I'm like, let me see your decree. Look at it. I'm like, hey, that's pretty good language. So I go to title and say, hey, if I record this decree, are we good? And they're like, oh, yeah. If you record it, it's good. So I just, record it or get a certified copy from the court, have the client take it to title and they record it. And then we're good. Problem solved. Pretty quick fix. But yeah, if you're an investor, you're wanting to look at the language of the decree and say, even if it hasn't been recorded, look at it, maybe show it to a real estate attorney or a title company and say, hey, if we record this, would this be good enough? And you're going to want to make sure that, you understand the timeframes, understand what exactly was done in the divorce before you enter into that transaction. So, okay, what are we dealing with? That's not to say you shouldn't do the transaction. It just says, look, if the decree doesn't have good language, you may want to plan for what is going to have to happen, which is, participation of the non-awarding spouse, or go back into court and get some magic language in that decree.
What can be done and what should we be looking out for in the event that both spouses prior to the divorce are on the mortgage or are on the loan and on the deed of trust, which is a lien against the property, and the decree is going to award it to one spouse, and pursuant to the settlement agreement or the decree, that loan's going to stay in place?
Yeah, this is a major problem. And we've seen this play out too. Spouse is awarded the property and the decree says, oh, not only are you awarded the property, but if you're, since you were awarded the property, you're responsible for paying the mortgage. Sounds great. Oh yeah, the courts told them they need to pay the mortgage. Well, what happens? Number
They don't pay the
one,
mortgage.
they don't pay the mortgage like they should. And they're always, I've even seen them where like literally every 6 months, there's a trustee sale noticed, a foreclosure noticed, because they get that far behind and then they figure out a way to reinstate it and they reinstate it. But what is that doing to the spouse's credit who's still on that loan but doesn't have the property? Right? I mean, it's just diving,
Down
it's
the
gone.
toilet.
Not to mention the debt to income ratio issues and things like that. That to me is even worse than not having proper language in the decree, because you have this spouse who's just out there, and has no ability to do anything about the problem that's been created, which is this spouse can literally not pay the mortgage, can cause credit to be damaged, and they can't do anything about it because the property's been awarded to them and they're in full control. And it's a major problem. They want to go buy another house. They want to take advantage of the market and the market appreciation, and they can't because this loan is out there. And so my recommendation is in a divorce, you need to really have an eye on that, from somebody who, if you're a borrower on a property that, the court's deciding who's going to be awarded the property, you need to, try your best as part of the settlement, if there is one, to make provisions to deal with that loan in a timely manner.
So let's say market conditions don't afford, let's say they agree with you and they're like, you know what? Not only do we're filing a divorce, we want to be done with each other. And that also means we don't want to be attached to this property anymore. But market conditions are such that we don't have any choice. Maybe that's because they bought at the top of the market and there's no buyers at that price for what they need to do to pay off the loan. They're kind of forced into that. How do you think it's best to transact that to protect the parties?
So one would be to treat it like a subject to transaction. And so the party that's not awarded the real estate would be given a performance note and deed of trust, which basically says, I will perform and I will pay. And if I don't, you can step in and you can pay so it doesn't damage your credit. And then you can foreclose and basically, take me out of the property. Now, they may not like that because of the fact that, you have a divorcing couple and one of them could use that note and deed of trust, as a weapon and weaponize it. And, the minute they're 2 days late, they're like, nope, like I'm going to foreclose. And now there's reinstatement rights and things like that, but they could start the process and, now they have to pay for the attorney and trustee and whatever. And it could be a mess. So that's one way you could do it. The second, and the one I probably like the most, is basically to leave the spouse on title, so that the spouse that wasn't awarded the property, leave them on title and say, look, if they don't have possessory rights with respect to the property, but I'm going to leave them on title. And if you go and you refinance or you sell the property within, say, 2 years, 3 years, 4 years, whatever you think it would take for the market to rebound, then they'll cooperate with you and, they will execute whatever documents they need to execute. So the court is ordering them to do that. And from there, you don't have to pay them anything. But if you don't refinance within this set amount of time and remove them from the loan, or you don't sell it, then they then have their 50% interest, and they could, either wait out the market. They could go and they can partition, and which a partition means you go into court and say, hey, look, I'm a co-owner of this property. Judge, order that the property be sold with the proceeds split, so they could partition it, or they could even come in and request the court order and require them to, do like a short sale on the property or something like that. So, you figure out what does that time frame look like and keep them on title with the understanding that they'll cooperate at a future date. And then, they don't receive any of the proceeds as long as the refinance or the sale happens within the set time frame. And then you order during that time frame for the party or the spouse that was awarded the property to pay the mortgage. But could they, have the same problems during that window? Yeah, but at least you have the ability to be on title. I've seen it where the spouse isn't paying the mortgage like they should. They're damaging the other spouse's credit. At the time, they thought, well, the property's underwater. But so we don't even really need to deal with the loan and whatever, and any equity or whatever. They were removed from title, and all that was happening was their credit's damaged. Well, then the property appreciates, and the spouse that was awarded it could sell it and take out a big chunk of change. And they're like, man, I'm getting hosed all the way around. My spouse can sell this thing, make lots of money. They're not paying like they were supposed to. And all I have to show for it is damaged credit. You don't want that to happen. And you need to put language into the decree to avoid that from happening.
Yeah, it's amazing how much planning can help. But at least in our experience, it doesn't seem like this is planned for the real estate implications at all during the settlement or the decree process. Would you recommend, or do you think it's advisable in a divorce when you're dealing with real estate, regardless of what side you are, to spend an hour at least with a real estate attorney, just reviewing, making sure there's not going to be any conveyance and titling problems after the fact?
Yeah. So whether you're the spouse being awarded the property or you're the spouse that's not being awarded the property, but maybe remaining on the mortgage, I think it's worth it for not only you to sit down with a real estate attorney, but for you and your divorce attorney to sit down with a real estate attorney and say, okay, here's what we propose as far as the language of the decree, the settlement, the final settlement. What are we missing from a real estate perspective? What do we need to do to make sure that we don't have any issues crop up in the future? And yeah, I agree. I think sitting down with a real estate attorney, even for an hour, would resolve some of this, where they could help, the divorce attorney kind of craft some language to make sure that, that spouse is protected and will not have these issues come up in the future.
Yeah. Mayo, I understand we have a couple questions.
We do have a couple questions. They're not necessarily related to today's topic. Would you guys still be interested in?
Sure. Why not?
All right. All right. So our first question here from Facebook, this is regarding subleases. With a lease option, can you sublease it?
The answer is yes, as long as the lease allows for it. So you can sublease it. And frankly, if you're going to try to acquire property via a lease with an option to purchase, you better make sure your lease has a provision allowing you to fully sublet it.
Yeah, go right to the assignment and subleasing clause.
Right.
It's usually always there. And if it's a commercial lease, it's almost always going to say you can't.
Right.
I don't know what the default is in a residential lease, but
you can't.
It's typically not.
You're going to have to change that.
Yeah. So watch out for that. Doesn't mean that the landlord can't approve it. But that's what you're going to be going through.
The other thing is, if you're going to do a long-term lease with the ability to sublet or use it as a VRBO, like a rent, they call it rental arbitrage. If you're going to do something like that, the state lease prohibits the changing of locks. Well, you're going to want to change locks. So you're probably going to want to put a smart lock on there, especially if it's a VRBO. And in that case, you need to strike that language, because otherwise, if the landlord or soon to be seller under the option gets cold feet, wants to back out or whatever, they're going to be looking for any violation of the lease. And that could be one of them. And so make sure to put in there that you have the ability to change the locks, and change them without even providing the landlord with access.
We did get one more question. This one's a good one. Does a quit claim work the same as a warranty deed as far as spouse relinquishing ownership rights over a property?
No, and you don't even want to use a warranty deed. But so let's just start with the idea of a quitclaim deed. They're not good documents. I'm just going to be frank. Don't use them. Title companies hate them. Now, granted, you're quitclaiming, which means you're not providing any representations or warranties as to title. You're just saying, hey, to the extent I have any interest in the property, I'm going to give it to you, or I'm relinquishing it to you. So I understand why people do it. Title companies hate quitclaim deeds. Warranty deeds are better, but really the document for a spouse in Arizona to relinquish ownership rights over a property is a disclaimer deed. That is what you want. You don't want a warranty deed. You don't want a quitclaim deed. You want a disclaimer deed. Can it be done through a quitclaim deed or warranty deed? Sure. They could, convey it to the other spouse as their sole and separate property. But the preference is a full-on straight up disclaimer deed.
Somewhere, somehow, people got the idea that the quitclaim deed was this magic wand that fixed everything. I think my favorite one was I saw a husband and wife, and one of them died, and they owned it as tenants in common. So there was no automatic transfer of title to the property. So the living spouse just decided to quitclaim her deceased husband's interest to her. I was like, yeah, you can't do that. That would be great if you could do that. That would be an awesome workaround, but you cannot do that. So any other questions, Mayu?
There was just one more follow-up question. I feel like I can guess your answer. The best least option to buy price, it depends.
Yeah, it would depend. I mean, for example, let's say that you want to acquire the property subject to, but for some reason, you don't want to acquire it right away. And come to our class on May 4th, and we'll talk to you about why you may not want to acquire it right away and what those circumstances are. But in that case, the purchase price is going to be the payoff amount of the existing loan as of close of escrow. That's going to be your purchase price. So what's cool about that is you have a long-term lease and you're paying the mortgage. You're reducing your purchase price as you go. So, that it really is going to depend on the scenario.
Yeah. All right, everybody. Thanks for joining us. That is our show this week. Make sure to join us next week. Next week is our 1-year anniversary. So we'll be celebrating with a best of year 1 show. Make sure to be there with us. Look forward to seeing you, and have a good week. We'll see you next time.
Have a good day, everyone.